Lord had fixed it for the next circuit. I will inform the matter for prosecution also. And he goes to the order, I will prejudice.
Which matter?
Not that.
Give the problem.
After this order was set aside, my lord.
Sir, he has taken time. You have served a copy of.
My lord, I shall be deeply prejudice. Kindly goes to the last
Sorry,
point of this
sorry,
order.
sorry. Now we remember.
What is mayor wanted to mention a matter?
Ordered in your presence and you are mentioning today. Peculiar. That's not the way. Yes.
What is mayor wanted to mention a matter? The matter was on this on 4/12/2024 and it was next circuit. And I have also informed the state government to for hearing.
Why?
This was become next circuit and I want to move the.
They want to, it has already been ordered. What can be
And
done?
I-
Call.
Item number 1.
Yes.
What matter was because of my mistake. I was not able to appear before your lordship. Yesterday, your lordship has considered for the one of the OQs, the order was passed.
Done in the next. What is the big deal?
If your lordship kindly takes it, it will take hardly 5 minutes.
No, now, no thought of that. Yes.
As a
Correction.
On Dr. Wilson's on behalf of the Special
We are informed that the name of Dr. Jalpaiguri advocate has wrongly been mentioned as appearing for the state in the earlier order dated 18/12/2024. It said learned advocate was representing the de facto complainant. Let the name of Dr. Arjun Sauri advocate be read as the counsel representing the de facto complainant. Order dated 18/12. Stands modified.
Item number 2.
I call the petitioner, my lord. Kindly fix the matter for the next circuit.
Item number 3.
Every day you are free to not to do. Next circuit, as prayed matter be listed in the next. Please don't appreciate this. Yes, next circuit.
Item number 4. On the basis of statement of proceedings from the principal accused 25 total of covers alert. No criminal antecedents and petitioner is custody about
24 bottles of cough syrup
25.
and brown sugar.
100 point something. 250 grams. Not from the judge.
Whatever it is.
Whatever that is, the one sugar is also there.
Don't do this, please.
Right.
Don't do this. Yes. There is no recovery from him. Where were they? How it has been recovered? What is the manner it was?
From the
How? Where were they? Near the border, on a truck? Where were they?
from the motorcycle.
From a motorcycle.
Person.
Only one person.
Only one person in the back, from his back, it was one motorcycle bearing number WB 64.
What did he say? He has got it from you.
Okay, yes. Okay.
Any past?
No, no. Actually, here is the report memo of evidence. Does not say anything regarding the detail of the case is there.
He was arrested. This person was also arrested.
On the same day.
No, no, he was arrested on. But this is the memo I have given. The second page of the memo. He was arrested on 29/2024. And the first accused was arrested on 15/9/2024. After 5 days. And thereafter no recovery.
He says on your direction, he was not procured for being sold in Rajasthan.
Page 13 is the statement of the accused. But I have seen it. Does the inventory going on? Before my instruction.
Yes. About 100 grams of
The case is not only full of anomalies and discrepancies, there are contradictions also. But if my lord kindly comes to if say third page of the FIR. Second page of the FIR, my lord, after the list of serial list. In the fifth line, it has been stated that to the effect that on 29/9/2023 at 14:40 hours, I received a reliable specific source input that the source code are used. The source information was received on 29/9. Whereas the GD, the charge sheet, all the things are stated that source information was received on 30th, the date of first consider. First GD. FIR 29, in GD 30th. No.
Where has it been said about 2029?
FIR. Second page of the FIR. After the list of serial list. 1, 2, 3, 4. Fifth line, my lord. To the effect that on 29/9/2023 at 14:40 hours, I received the reliable specific source input. That is number one. Then there are other things, my lord. The formal FIR, my lord, can. Now let the fourth page of the FIR. Now let fourth page of the FIR. Fourth page, first paragraph, last line. Stated, I level the seal and seat article and above noted explain the whole process of start seizure and the level was made under the coverage of the videography by the videographer Net Somnath Ratto in between 17:15 hours to 19:45 hours. না আচ্ছা আরো অনেক কিছু কথা বলতে minus of inclusion so it has been stated
Yes.
Malak, page number 4 of it. Archon Cesar will come between 17:15 to 19:15. Fourth page of FIR, first paragraph, last line.
Yes.
The photographer reached and entire thing was photographed. Now this is the statement of the photographer. He reached at the spot at 6 hours. He reached at the spot at 6 hours. Mane after such consider all the things have been possible. Now the videography has been mandatory by the judgment of the
15,
अपने अभी बोले नहीं अपने 15
17, 15 hours.
yes
To
but
1945.
yes but he reached at the photographer reached at 6
It's written the whole process of search and seizure started.
Yes.
Whole process.
whole
The photographer was informed.
no photographer was informed he has to be and the single list of the says the thing was seized at 17-15 hours. Number 2 now photography is mandatory by the judgment of Honorable Justice Bakshi.
1,175 bottles.
That is different thing. That is number 2. Number 3. PW2 statement of PW2 in his deposition. Because this has not happened. That's why right from the inception, from the receiving information, cross-examination. I wrote my signature at the police station on the plain paper.
This is in the trial.
These are the trial. That was the difference. Now I am just showing that. Then the minor can take to the chemical examination report, which is very vital. I have annexed it with my chemical examination report, my lord.
See if there's a good practice.
My case number running case number 12, my lord.
What is it?
Chemical examination report.
What does it say?
Items were seized on 30th September 2023, and it was sent to the CFSL after 45 days, more than about 2 months, more than 2 months.
68 days.
Yes,
68 days.
well, 68 days.
Yes.
So the thing is that it has to be sent as soon as possible. There are several judgments. There is standing order of 1 of 88. There is judgments. Yeah, my lord can refer to this judgment. This is mandatory. No. There is judgment of Kasim. Not only that, my lord. It was sent on 7/12/2023, and it was received at the CF Kolkata, which takes only 1 day. It was received at 13/12, 6 days. So there is the whole chain is broken. 52A and the standing order 188.
Sir, I come to 52, madam. 52.
52 has been clearly described in this two judgment, Venkatesh and my lord that Kasim. It has
He
been
was the only person who has been arrested.
No, two
2
persons.
persons. 2 persons.
Both of the petitioners.
So both are petitioners.
Both are petitions, my lord. So there is gross violation, my lord. It is no, it has to be said as soon as possible. 52 clearly says. Then one standing of order of 188, it is stating it has to be stated
I
on
have earlier also moved.
My lord, it was
My lord,
rejected
my
twice.
lord, these things are not.
You should say at the very outset.
It was rejected on 7th of November.
Everything that you are saying is recorded in the order.
No, these things are not.
Not recorded.
No, only this.
Let us see. Come to an X-ray.
Only
Come to an X-ray. When you say no, then we are asking you to come to an X-ray.
not only.
Please come to an X-ray.
My-
6 p.m. delay in sending, everything is there, and you are saying no.
Everything.
No, only 6 to only that thing. But this vital anomaly, it was said after.
Anomaly, it has been rejected 3 times. You are not telling us.
This,
You are arguing as if you have been languishing without any consideration for 1.5 years.
my lord, this
Once you have not pressed,
one.
twice rejected, and once last occasion you have not pressed.
But this serious issue was not
At
raised
the
at
top
all.
of your voice.
My lord, my lord, this serious issue was not taken.
Very
It
serious.
it was not,
Hardly there for 1.5 years. A huge quantity.
this is a vital thing which have never been gained.
As earlier made program of fail twice. On 10/4/2024. I think there was.
Number 6.
The contraband were seized from a public park.
Start from here. Or 18.
Not today.
I don't need.
No, not today.
Why, how much time it
Tweets,
takes?
madam, tweets.
How much time it takes normally for you to get the CD? 1 day. Then not
I recently copy yesterday.
as date is on, give the date of sale.
Tweets.
Normally they give it to you within a day.
Within a day, within the surrounding weeks, that is, outstation. And they give it a stick.
1 hour.
Please.
None of the except.
Seven.
Not of yours.
Not today, not next circuit, not today.
7 not today. 7 not today.
None appears, not today.
8.
Eight.
7
Here's the 9.
8.
the interim your lordship. I tried to contact my client but could not.
This has been adjourned every day.
Yes,
It is that matter.
yes.
He could not contact.
Yes, sir.
Complainant is also surrendered. The complainant is not represented.
No.
As earlier also represented.
That is why we are asking. We see that somebody was appearing. One Mr. Chandan Rai. What is the allegation on false promise
Yes.
of marriage?
Yes, sir.
How long?
8 months, no, sir. 8 months.
The refusal to marry. That is the allegation.
Yes.
Can we see the FIR?
Yes, sir. Entire page number 1. Page number 35.
He was in jail.
Yes, Lordship. 87 days in custody, Lordship.
Where was under which section?
376, 470, and 500.
Is it?
I have written that, submit that, this is a renewal of it. Renewal on page number 10, P1, it's decided that this petition earlier also 57 days in custody, besides the application, but that was allowed because of tax sheet has not been filed. I know now the tax sheet has been filed, and he is done custody for 100 days. Lordship, and this so far as allegation is concerned, here is a civil dispute.
What is the nature of injury?
Well,
Kindly see the 164 statement of the victim wife, the injury, let's see them first. Postmortem report, page 89, head injury. One or repeated, repeated.
one.
They are neighbors.
Fixing a gate, what a land, there is a castle has been held and the victim has filled down in a drain. That is what
Did
sustained.
you sustain any injury?
No, the victim.
Did you sustain any
No,
injury?
yes, I have, no, because of they have an assaulted, I have injured in my
Is
leg.
any report?
No, no report, because.
But as per the constitutional statement of the wife of the deceased, this petitioner is the principal as well. As per the
He has hit on the head.
yes,
With
with bamboo stick.
No, no. Lordship, another accused has been absconding and there is the one taxi has been filed. So far as trial is concerned, there is no possibility immediate trial.
who is the other accused?
This is my brother. He is another base, he is recently another, but he is also on the spot. But say it's.
He is separate.
Lordship, and it is already in custody and so there is no chance of a further focus of investigation because of taxi has been filed. And the accused petitioner is a teacher, Lordship, actually. Nothing has been recovered. Oh, I don't know, nothing has been recovered.
He's your full brother. The deceased is your full brother.
Full brother.
Cousin.
Cousin. This is cousin.
One of the accused person still absconding. But this petitioner is the principal affair.
I am in the custody for and this so far is the.
There is an offer certain the progress of trial. There is no progress. He is not appeared.
Not one person is still absconding. WP processing is going on, my lord. That is why trial cannot be concluded, started yet.
Who is not to win it. I still there's another accused. So I will tell us only language in the custody unless. Tashi said what is somebody in worship. That's been for trial is concerned, there is no chance of immediately.
The opposition lordship had directed me to file the.
Opposition that I have not discovered, but they have been. I don't they
Yes, you may.
In this case, what has happened on the fateful day, there was a dispute with regard to the locking of a gate between this Munirul and Abdul Ghani, the petitioner, and with the de facto complainant's husband. When the when the Munirul instigated this petitioner to assault the husband of the de facto complainant, and de facto complainant was also, and this Munirul is absconding, he is constantly threatening this de facto complainant to withdraw the case.
I am not monitoring. They have been also filed a petition against this investigation.
So that is
That is been also been satisfactory and that is not being interfered.
How does that help you?
No, Lordship, because of their whatever.
How does that help you? You dispute that one of them is absconding. You cannot. That's a hard fact. How does that help you? That is determination. Because immediately he has gone, perhaps that is why that it has been dismissed. What do you want?
Worship, I mean, this is any condition, any condition. Because of, I have a one child, worship, he is in studying MBBS. So due to my custody, my child is in suffer. Any interim or
He will treat the injuries.
worship?
He will treat the injuries.
No, he will not because of the, he is
He is studying in MBBS.
MBBS second year. Worship is, worship kindly,
You are not inclined.
worship kindly give me an interim, because of worship.
Just look at the nature of injuries sustained.
Nothing has been recovered from. Worship, actually, he fell down in a drain and that will be sustained
We
injury.
don't know.
No, worship, if this, kindly see the, there is any assault, no assault has been there. There is been, actually, they fell down in drain and that will be injury. Even,
He fell down or
fell down, that is why,
he was pushed into the drain.
that is that, worship, kindly say on that point, worship, because I am on custody, how far, 100 days. Worship, and interim will be granted, I am not visiting my place. I am not going to visit my place.
You live next to the complainant.
Next, I am not entering into the jurisdiction of this company.
You are residing next to the
Next to
complainant.
Actually, I am not entering into the my house. I am residing another one. Worship.
May it please your lordship. I beg to appear through video conferencing.
Yes, yes.
Lordship, this is a bail application.
You have a right to appear.
I'm grateful. I'm grateful.
Before my last starts, my lord, the last occasion, my lord, there was a direction upon the hour to be remain present with the original seat. So we have already informed, but they are not, he is not present.
What is this, a bail?
May it please your lordship. This is a bail under the Foreigners Act. If I may just introduce the matter.
Just give us.
This is it.
Just give.
Please.
You have the case diary now.
I have the case here.
Why the IO is not listening to you?
But necessary order may be passed, my lord. There must be one order. Because this is the Khadibari PS, we have seen earlier also, they are not. We should have some respect for the order of the court. That is very good. Even we have informed, as informed by my office.
Last circuit, they have been taking action, not in this circuit. Kindly see.
You don't think we have seen the past orders? Then why? We're just trying to ascertain what is.
Is that the certified copy has been sent and there are some pages, but it is very difficult. If I vote also, be very difficult.
Let us see if we find that we are in any way unable to proceed, then let us see. Yes, please.
Please, I'm grateful. Lordship, this is my, I must point out at the outset, this is my third bail application before this honorable court.
Yes.
The first bail application your lordship would just have was rejected by your by a coordinate bench of your lordship on the 12th of February 2024.
Yes.
And your lordship may straight away come to that. Before that, I'll just give your lordships the just 2 dates before that. I was arrested on the 12th of October 2023. And the circumstances around my arrest were, I am a Chinese national. I'm an engineer by profession, 54 years old. I had a valid visa to work in Nepal. While I was working in Nepal, it is my case that I was being driven by 2 Nepali nationals in a Nepali registered vehicle, in a Nepal registered vehicle. And instead of our case is that there was a mistake. Instead of taking a right when I should have taken a left, I ended up at one of the border checkposts at Panitanki. And there within 600 meters, as soon as I entered, I was apprehended by the security forces there. They asked me whether I have a visa. I said, I don't have a visa. They took my passport and I was arrested along with the 2 Nepali nationals on the same day. Next day, we were produced before the before the learned trial court. 7 days of PC was taken. We were released before that. We were in judicial custody and I've been in judicial custody since then. The 2 Nepali nationals, also may only note, because of our relationships with Nepal, they were obviously released on bail immediately after the charge sheet was filed, given the fact that they did not require a visa to enter into India. Now, unfortunately for me, since then, they have not returned to the learned trial court's jurisdiction. They have been absconding. So the charge sheet, your lordship would note, was filed on the 9th of December 2023. After the charge sheet was filed, I made my request for grant of bail before this honorable court. Your lordship would just have that at page 11 of my bail application. If I could request your lordship's attention to the second paragraph. This is an application for bail at the behest of the Chinese national who was apprehended by BSF personnel in the Indian territory without any valid visa granted to him. He was accompanied with 2 Nepali nationals. Submission is advanced by the petitioner that the Nepali nationals have been granted bail. A case has been registered under Section 14A of the Foreigners Act against the petitioner. It ought to be contended that the petitioner, being an engineer working as a project manager, was directed to go to another place to supervise the other projects. And being ignorant of the geographical territory of the country of Nepal and India, he's been arrested, having no such foul intention or ill motive in this regard. It appears from the record that the charge sheet has already been submitted, holding prima facie petitioners guilty of committing an offence under 14A of the Foreigners Act. So far as the other 2 persons accompanying him are concerned, they being Nepali nationals, have been granted bail, and in fact the charges leveled under 14, and in fact the charges against them have been leveled under 14C. 14C, your lordship would note, is abatement. And thereafter, your lordships considered the matter and said, on the grounds of parity, perhaps bail cannot be granted to the petitioner before your lordship. Thereafter, if your lordship would just have the next page, I moved a second bail application, which unfortunately I was unrepresented on that day and it was dismissed in default. Now, since the 12th of February, and if your lordship has the, I'm grateful, if your lordship has the Foreigners Act for a moment, 14 capital A is the penalty for entry into restricted areas, etc. If your lordship would have, I am being prosecuted under B, 14 capital A, subclause B. So if your lordship has that,
Yes.
whoever, your lordship has that. Whoever enters into or stays in any area in India. So those are the 2 circumstances in which 14B is attracted. Without valid documents required for such entry or for such stay, as the case may be, under the provisions of any order, etc., or any directions given thereto, will be punished. The range of sentence, your lordship would note, is 2 years to 8 years, depending on the degree of infraction and depend on the discretion of the learned trial court. 14C, for which the 2 Nepali co-accused have been prosecuted, is for abatement. So the substantive offense, Kwame, is 14A subclause B. Now, the submission before your lordships is this, that on grounds of parity, your lordships have made it entirely clear that perhaps we are on two different pedestals, and we bowed down before that. The substantial change in circumstance since your lordship's decline of my bail in February of last year and today is that the trial has not moved forward. Cognizance, this is a matter that has been committed before the learned session. That committal has taken place. Cognizance has been taken. And now arguments on charge have the case has stalled at the stage of arguments on charge because warrants of arrest for the two Nepali nationals are being unexecuted. And that your lordships would have in order after order of the learned trial court. Insofar, and the next date of hearing, I'm instructed, is the 31st of January, where again, the orders on charge have been, that process has been stopped, pending warrants of arrest to be executed against these two Nepali nationals. Now, your lordship would have that in these circumstances, even in other, I appreciate that this is a foreign national, but in cases of heinous nature under UAPA, under NDPS, your lordship and the Honorable Supreme Court have now repeatedly said that all these offences will pale away even for foreign nationals, where there is delay that is not attributed to the foreign national himself or to the litigant himself. I have now spent, your lordships would kindly note, 14 months in custody. I am willing to be put to any terms that your lordships may direct, but I must be released on bail, and I will face this. This is the I'm so sorry. 2023.
12/10.
October 2023, I was arrested.
And what is the significance of 12 to 24? That's the last
Well,
order.
that I must point out, that is your lordship's order rejecting my bail on parity. So your lordship would ask me, and with respect, that what is the change in circumstance? The change in circumstance is this, that there is no movement in my trial for the since the order on cognizance. And lordship only note, cognizance was taken in May of 2024.
The council, what is the state in respect of the other two?
Thing is that, Malad, he has finished, Malad.
No, just one last point, if I may. Sorry, I'm so sorry.
Yes.
With your lordship's permission, if I may just direct your lordship's attention to page 38 of my bail application. I've taken the liberty of placing a judgment of a coordinate bench of this honorable court in my bail file. It's an unrelated matter, but similar facts in Mohammed Sapon, where your lordships were pleased to find, if in para 1, that he was in custody for 410 days. This is a Bangladeshi national. And your lordship's observations were in para 3, starting at the bottom of page 38. Prosecution may have a very strong case, very good grounds for securing conviction. However, petitioner cannot be kept in incarceration for an indefinite period of time without concluding the trial within a reasonable period of time. We see very little possibility of trial concluding at an early date. Petitioner is in judicial custody for more than a year and 1 month. Right to speedy trial under Article 21 is available not only to an Indian national but also to others. So that's the sum and substance of our prayer before your lordships, and I'm obliged for a very patient hearing.
Malad, first of all, Malad, actually the status of this petitioner, along with the other two accused persons, are different. The other two accused persons, they are the citizen of Nepal.
That is very.
And their thing is that they are under the 14C, so they have been granted bail. Now they are absconding and the trial could not be there. So whether they have filed any petition for splitting up the matter and conclude their trial in the lower court, that is one point. Now they have come before the court on the ground of there is delay in trial. Second is, Malad, regarding the Nepal and India, there is a treaty. Any Nepal citizen can come into India with their proper identification, whereas in alternative, Indian citizens can go to Nepal with their proper
Not required,
identification.
he's
So
not,
this is
he is
fine.
not claiming.
Now, my lord,
directly or-
this is a case of national interest. It has to be taken in such a, he's a
Therefore-
Chinese national. My lord.
You are saying national interest, what is that from the records?
From the record, my lord, the things which have been seized from him,
What
just
has
my lord, a Chinese passport has been seized. Second is tourist visa. Ping. No, this is not that. And one of the Lenovo laptop, my lord, with charger and mouse. Then time food to Kathmandu flight ticket. So what was the purpose of his? Because he is an engineer. It's not that he's an
What flight ticket?
from Kathmandu to flights for his Kathmandu to his China, my lord. That ticket was also ready. So what purpose? What is the purpose he entered into 600 meters? He is not an ordinary man. He is an engineer. He is a master. Yes,
He was basically apprehended at the border itself.
Yes, he crossed India border and he entered 600 meters and the SSB camps are there. The SSB personnel there arrested him. There might be some reason, my lord. He cannot be taken as like a light way.
What is the material?
Materials, sufficient materials are there. Now, I was late, my lord. Just now he has arrived with the original seat.
Let us see.
Maybe certified. Original name of the certified gives. Original the
As original CD
One thing can be done, but there may be a direction to the trial court for speedy, not to speed up the matter and for speedy disposal, my lord. That can be done, my lord. Because, my lord, lots of things are involved, my lord. China, the biggest enemy of the market.
Is there any material to show that he was overseeing in the project or something in Nepal?
Please, your lordship. I'll just point that out from my bail application. If your lordship would just have for a moment, your lordship would just have page 23. Please, 23, your lordship. So these are the documents that we've been able to collect. Your lordship would also appreciate we are also operating under a slight handicap that the one person who can help us is in custody. So whatever material my learned friend in front of you has been able to collect, we've placed on record. This is what we've received.
Oh, is
That
this, does this document, it is a document
Please,
regarding some installation and service contract of a hydropower station?
please. This is what he was. If your lordship would just have page 30. In fact, I think that will be clearer. Page 30.
You is that can he show from this in any way that it has any relevance to him?
30. Page 30, your lordship. I'm sorry. 30. An extra F. Your lordship would have, this is a letter from a company called Asia Pacific Power Tech Company based in China. And this is a dispatching letter to the visa section in Nepal. And this is that we so-and-so would like to confirm that Mr. Li Xiaokang, who is the petitioner before your lordship, is working in our company as project manager. Due to needs of the company, we decided to send him to Nepal on 1st September to complete installation and guidance, commissioning and trial operations, escrow operations, and on-site management of the mechanical and electrical equipment from water to electricity at the site, including so-and-so of our company. His specific personal information is as under, and that is the information. We ensure that he complies with the laws of Nepal. So these
Documents, how they got these documents?
What official? This is given by his employer.
Directly to the Nepal visa section. Stop, dear Nepal visa section officer and custom officer. How you got this? These are confidential documents.
But these are documents that he, no, these are not confidential. My learned friend may not be that dramatic, please.
But only reading is not after his conviction, if his proof that he is a Chinese national, after his conviction only is pushed back. If he's granted bail, one he is out, again he commits the same mistake on the foreigner side. If he's granted bail, only that must be, he must be pushed back to his country. Because if he's granted bail, he has to stay in India. Every day is committing the crime.
May I just make one submission in that regard? I'm so sorry.
Yes. Why
Please.
did you file
My-
a motion for splitting the trial?
Just one submission, Lordship. My friend has sought to create a situation that I was here for some nefarious purpose. That is not what I'm being prosecuted for. I'm not being prosecuted under the Official Secrets Act. I'm not being prosecuted for spying. I'm being prosecuted for entering the country without a visa. And in fact, your lordships, I just one judgment I may simply point out. I'm just for your lordships consideration. If my friend just
Anything, if both of you are, please let him complete. We are here. Yes.
please, there's one decision of the Honorable High Court of Calcutta, Christian Mark Durant, where I'll just request my friend to pass over a copy, 2 copies. Where if your lordship has the Foreigners Act, Section 15 has been interpreted in favor of a foreigner who may have entered India by way of a mistake. And if your lordship has that, para 6 of this judgment, it is passed by a learned single judge of your lordship's court. And with permission, I'll just cite that. This was in the case of a Swiss national who had entered twice. He had been told that he has to enter by land, by air. He tried to enter once through land, he was sent back. He then made another attempt to come through Sikkim. And at para 6, if your lordship would have, after initiation of the
Get up in. That's great. It's in the next service.
deeply obliged.
Yes, yes. Yesterday also. Next circuit. Yes.
Yes, I want to put that for the petitioner also.
Yes.
What's- They want to speak to the-
Why? We allow you to first place the case. If required, we'll allow you to don't. Place your goods. Come with your case law. Not. Why? Yesterday also these matters.
Monday.
Just finish 6 questions. If you're busy, that's good.
On basis of co-active statement, our name is incorporated in this case.
Her name.
Yes, worship petitioner is a lady and no recovery from the position of the petitioner. Charge sheet submitted, investigation completed.
Petitioner name is Sushila.
One accused person in this case was granted bail.
Petitioner used to know lots of trading regarding anyway.
The allegation is that she was trading.
Yes, smuggling. Smuggling is the putting the contraband substances.
On basis
Cough syrup.
Cough syrup. Ganja, ganja.
Ganja.
Translation submitted WA issue again.
Fancy not ganja. Cough syrup.
What is it? Ganja or fencetil? Three bottles of fencetil. Many kinds of cough syrups. And what did he say about you? Sarup Badia, what he said about you?
On basis of one accused person, premises was arrested. On basis of premises statement, charge sheet submitted. Investigation is made.
No statement made by this person.
No.
Total recovery, what is the total? There are 2, 3, 4 brands of cough syrups. What is that total?
That is at page number 19 bottles of cough syrup.
19.
Total. Page number 12 is the history.
And from him, from her, there is
Yes, she was a part of the gang, but she was not present at the time.
no, but from her, there is no recovery.
She's responding from the co-accused statement on that relevant point in time.
Anticipatory.
Yes, it's anticipatory. After the seizure, everything was done. Now her name transferred from the 161 statement of the co-accused. 161 of the co-accused I have given before the
That we are looking at. Any criminal antecedent? No. Bottles of cough syrup have been recovered from the
I thought that this time, meeting has been notified, it was probably so that after the petitioner, victim, and neighbor,
They have presented, she is not represented.
after the history of the appellate, like, what did I have seen? He was after the petitioner.
Is there any affidavit of service?
That's been doing for 1 day. No, she is. 1 day. 1 day.
Have for the state.
My lord, I appear for the petitioner. My lord, may I, my lord?
Yes, please.
Yes, my lord, may come to the first order. Order number 1 passed by the coordinate bench of just comprising of Justice Sampa Sarkar and Justice Partho Sarathy Chatterjee. May I take you to the brief of the matter is, my lord, this is the matter of a failed love story, my lord. Now, my lord, once my lord may come to the petition, the list of dates. The fateful incident occurred on the 30th. The boy.
There is a 9-day delay.
Yes.
Right.
And the prosecution were instructed to take instructions with regard to whether there was any inquest or autopsy made or not. To what I submit is that cannot be a part of the CD. The autopsy report and the inquest cannot be the part of the CD as
that he has committed suicide.
My lord. After the burial take place, then the FIR was generated.
How an autopsy will be relevant for this?
Your report has not yet been corrected, but the allegation is of committing suicide by taking
caused the FIR? Who has
father of the victim lost the FIR. 28 years guy committed suicide at the house of the he consumed poison at the house of the accused petitioner, lordship. And so far the allegation is concerned, the accused petitioner said that there is a love affair. Obviously, so far
the father says that he has consumed poison and committed suicide.
Yes,
that is the allegation.
That is the allegation, but the lady who is the petitioner here, she placed the poison in front of her and told her to consume the poison and die. This is
how the father knows about this fact.
The victim stated to the father.
Oh, where is that?
In the FIR.
Is the FIR annexed with the
FIR is in Bengali.
Whether it is annexed or not, that we are asking.
It is annexed. It is annexed as in page number 8. P2, annexed P2.
I have heard it is written in the FIR in the first page. এবং I had heard every incident from the mouth of my son. First page, last 3 lines. Investigation is still on.
May I, my lord, now?
The victim was also assaulted.
May I, my lord?
9 days, it's only 5 days.
My lord, may I say something?
9-day delay in lodging, it's not 9-day delay in lodging.
My lord, may I? My lord, the fateful incident occurred on the 30th. 30th, he allegedly consumed the poison. And on the 8th, he died.
On 8th, he died.
8th, he died. Oh, sorry, on the 2nd, he died. I'm very sorry. On the 2nd, he died. On the 8th, he lost the complaint. Now, my lord, there are two facets, my lord. Now, my lord, my lord, may I?
Yes.
Now, my lord, there are two facets, my lord.
Yes.
Now, my lord, if that would now PM report or the inquest report, what has been asked for cannot be there. The reason because they have not made the FIR while he was alive, but had made the FIR after his burial take place. Second point, my lord, he was as he consumed poison, he was subjected to various sedative medicines, then a emotional tide, and afterwards his father also faced the same as he lost his son. So it is the exaggerated form of the what incident has took place. Now, my lord, I would ask Mr. Gopal to hand over one of the Supreme Court judgment of Ashok Kumar. Mr. Gopal, can you please hand over the judgment of Ashok Kumar?
Okay. One indulgence. First of all, from the FIR, it is absolutely clear that on 30th October, when the victim went to the house of the accused petitioner, he was assaulted, and subsequently the poison was placed before him. There was a clear amendment.
Now, may I, Mr. Chatterjee, may I haven't completed my part. Please, allow me. So, my lord, in this judgment, in page number 3, para number 12, the Supreme Court, what it states that there has to be a specific purpose to be served, what has to be stated by the prosecution as to for what the custodial interrogation is required, and prima facie they have to show that the event has actually occurred. Now, my lord, I would say what surmises the prosecutions are placing, it is placing on upon the FIR. No autopsy report has been made. Now, if the matter would have been so imminent, the father would have then and there made an FIR. After the victim has consumed the poison, the hospital authorities should have informed the police. Nothing.
Relying upon is concerned with 468 and such offences.
Yes.
document based offences, whether custodial interrogation is required in such an offence or not. You are trying to sustain your prayer for bail in a.
Now, my lord, why I say this?
Being,
Now, why I say this, my lord? What specific purpose would it serve if I stay behind the bars? I am a mother of 3 minors.
That is
That is the question which
yes.
may arise if it is a document based offence like it is there in this.
No, my lord. At any time, I may be called. My lord, then it may be kept on the next circuit, my lord.
After hearing when
You have already argued your matter.
after hearing this type of next cycle is not.
No, my lord, I met because my lord in last order, my lord.
Yes, what is there in the
In last order, my lord, the prosecutor were asked to show the inquest and the autopsy report.
Yes.
The FI is an exaggerated version because there cannot be a clear indication as to what has actually happened because the burial take place after 8 days, after 3 to 4 days. The FI is lost for what?
You are the only person who can shed light on what transpired in that room. Yes,
that I am telling. In that occasion, my lord, I may be called for the interrogation. What is the requirement of my custodial interrogation, my lord? I may be called. I am a mother of 3 minor child.
You have 3 children. You are married.
Yes, my lord. It is stated in the FI in the earlier order. I have annexed the birth certificate.
Do you think shouting helps you?
No, my lord.
Doesn't help. You are married from before. Are you married from before?
Yes.
He is married from.
Married. There was a love affair. Subsequently, she refused to continue the love affair and called the victim in her house and assaulted her and then placed the poison in front of her and in front of him and told him to consume the poison. There was
that allegation. How the father is saying you don't know.
because father is in the last 3 lines of the FIR, the father has clearly stated, Lordship, that I have heard the entire incident from the mouth of the victim.
Come with the reports as per the last one. Next and next.
Much obliged.
Last one.
Good. I report for.
Yes.
Lordship, I have a relation with my head. Lordship, on the last occasion, Lordship, direction given up on us to provide the details of the victim to the eye, Lordship. We have accordingly comprises when and provide the details. Details to the OC Shiful Kuchi and the SDPO Mathuranga. I'm the then grandfather of the principal actress, age is about 76. They got married, they living together. They have contacted, they don't want to contact because they are living here.
Your grandfather of victim, what is the age of the victim?
She's major. She's major. They are willingly get married. I have annexed the marriage registration certificate.
Who is the complainant?
Father of the after marriage complaint has been made. As the father of the victim is not happy with the marriage. So
Both are adults.
both are adults.
To 19 years. So both are adults.
Adults.
All the family members have been made an accused.
Not sure. Including the grandfather, is 76 years old. What role I have in their relationship?
There allegation of kidnapping also.
But across statement of the witness that this petitioner has no knowledge about this.
No, is there allegation of kidnapping in the FIR? There is.
Generally, that will come. The father, that is that the accused person number one, page kidnapped her and raped.
And does he say that they have solemnized marriage? He doesn't know.
He doesn't.
He only says that he has taken her away.
But marriage registry documents I have annexed.
They are asking about the FIR.
Not sure.
It's only a case of taking away.
Not sure.
And for how, when the occurrence has taken place? What is the date of occurrence?
Not sure. The date of incident is 31st of October 2024. FIR was on 12th of November 2024.
11.
12th of November. 12th of November. There is a delay. Registered on 12th of March.
Yes. As per the complainant's version, You are getting these matters adjourned every day. This is the final adjournment.
28.
And for the petitioner, my lord. My lord may come to the FIR part in page 8.
FIR, you have annexed the FIR.
Yes. It's written information, page 8. Now, my lord, I would draw your attention to the last part from second paragraph.
Let us read.
Yes, my lord.
But in this case, Mr. Mirza is there. Kindly make it short pass over. He's moving a matter before the court number 2.
Let me.
May I, my lord? My lord.
Yes.
Yes, my lord. The CD must contain two things. One is the medical report, which shows grievous injury, and the ligature mark in the medical report, as because they have stated the gold chain valued at rupees 1 lakh was snatched from them. And the FIR was made then and there. Police came and rescued them. My lord, may see the list of dates at the first page of my petition. 30th incident occurred. Written information on the 38th, FIR at 1:12 at midnight. And the co-accused, Mr. Bhombal Roy, is under judicial custody after police custody has been finished. No, and the petitioner believes that there is nothing that would show that there is any indication in the medical reports of as to grievous injury.
Just now you said there's a injury containing a ligature mark.
Now, there must be.
But there is no injury.
No, nothing. And police came in this spot and rescued them. What they have stated.
Just now I have received it.
Go through it.
Injury report is page 4.
I do not know whether it is a grievous injury or not. It's just a case of simple road rage.
You know it is not previous in any, just you were telling us that there is no previous.
No, what my instruction is to. It's just a case of road, but this medical report would contain ligation mark if this written information is taken at the face value.
You said page 14.
Four. Nature of injuries have been described. Page 9 and 10 are the 161 statements of the eyewitnesses who were present at the time of occurrence.
How does he know the name of the attackers? He has said that I have been attacked by unknown persons. And in the last of that paragraph, he says, I identify one of them as.
In the last paragraph.
During the confrontation, my lord, I think the name has been given, my lord, because there were.
And he would have said, we have seen such allegations also. I don't know, I can't know, identify, but I heard that he was being called by this name. That is not what he is saying.
161, their name has been specified.
How does he, when he says in the FIR that they are unknown attackers.
Fire is not the one, the encyclopedia of the case.
But FIR not to be at variance. It's not an encyclopedia, it can give more, you can give more details. But not an encyclopedia does not mean that it has no value whatsoever.
That should not be a height.
Contradicting statements.
Not an omission even, it's rather a contradiction.
Variance.
You say you don't know and then you say one of them I identified. These statements are also not corroborated. It is alleged by the complainant that along with his family, when he came out of the restaurant, there was a scuffle which ensued on account of some irregular parking. So he alleges that thereafter he has been attacked by unknown persons by knife who have snatched his gold chain worth ₹1 lakh. Submitted by Senate Council for the that there is a stark variance and self-contradiction in the FIR itself, rendering the entire case to be suspicious. So the complainant has alleged attack by unknown persons, however, later in the same FIR discloses one accused person. Both accused persons. There is no injury sustained in the alleged incident. And over a trivial dispute, petitioners have been implicated in this case. The Land State Council opposes the prayer. The material during the investigation has been shown to the court, from which we find that the statement of independent witnesses appear to be prima facie not supporting the allegations. The rebel submissions, the material in the investigation were inclined to allow the petitioner.
My lords, my lords.
₹5 lakhs.
Allegation she was correct, and I also annexed the voter card. And we also,
The complainant was married.
yes, madam, and married. We also applied for marriage registration, madam. And thereafter, second of that, she was married. For this reason, marriage was not. Oh my God. I also annexed the voter card.
They are both the adults.
So, sir, page 11, madam, is the voter card. Of our voter card. Very good.
It must be supporting the allegation.
And next is an application for marriage.
Born in 2002.
Yes. An application for marriage registration. Therefore, marriage she was married.
That is your defense. That
Both are mentioned. And it's been
return of money, sir.
nothing was taken, only allegation of demand. Only allegation I demanded and it is married. There is no allegation I accepted.
She says she has paid. That's not the case in the FIR.
I did check in.
Let's state council.
What is 30?
Third case that is not available. Not.
31? 31? 30 not.
31. No, Mr. Kapil Bhattacharya is appearing in this case. He is actually not good enough. Can't make it one. Thank you.
32?
As read next sitting.
33?
Same.
34?
In this matter? Yes. Funded. Not this.
Right?
Thank you very much. Let me make it on Monday.
36?
That's 36 entry for
85 and 109 of it.
Mr. Kapil Bhattacharya is that very much.
Not good. He is here.
Yes, sir.
He is here in proceedings.
In this matter, Lordship, out of country, Lordship, they are in-laws and the particular person was assaulted in the apartment.
37.
7.
Yes.
But I'm for the petition.
The case started in the section 85, 117 to 109, 1 and 35 of the DNS. The corresponding sections of the IPC 498A, 325, 307 and 34.
The petitioners before your lordship are the father-in-law, mother-in-law, brother-in-law, and sister-in-law of the de facto complainant. Lord, general and omnibus allegations against the in-laws have been leveled, stating that they have tortured the lady. But she sustained some injuries, Lord, allegedly some injuries. But the main, Lord, the person who is responsible for this is the husband.
What is the nature of it?
Lord, minor, simple injury, Lord, minor.
Can you read this? There's something multiple between.
Duty assault done by the husband, mother-in-law, brother-in-law happened on date 24 at around 1:30 p.m. Multiple blunt trauma all over the body. CO pain 48.
This is the information supplied to the doctor by the lady herself.
And the treatment which was given was one
Where is the doctor's finding regarding them?
They are not. She was admitted, she was discharged, and she was given one pan D and zero dose F. One tablet.
Painkiller and paracetamol.
Fantasy.
Yes, Zerodol is the pain.
Zerodol and pan.
And almost everybody. Yes. The petitioners before this court are the father-in-law, mother-in-law.
Lord, I pray for time.
is a forest wildlife matter. Wildlife matter, my lord. So we don't have a mechanism, communication mechanism here, like police we have. People
There is some seizure, not from me, madam. There is some seizure.
sorry, my lord, yes.
Seizure of forest product.
Forest product, wildlife.
Gun and an antler of a deer.
Kochi. CD will be required. Next circuit, my lord. It takes little time. Forest, they take little time.
From which place? From which place? Here only, my lord. Try to get it. Yes, it was filed on the 17th of December. My lord. He should have come by now.
We have a communication problem in the forest.
Let's see, not today, what we get.
Not for the man, kindly fix it on please. Monday I'm not available, please. Please, I will try to. Phone jurisdiction করুন আমি একবারে করব।
My lord, tell it for obtaining case study. For details of investigation.
Online করুন।
My lord, Tuesday will have personal difficult. Next, sir. He's getting the records today only.
My lord, I have
No, not today, then no order is required.
my lord, no, Monday I will not be here.
Is this Monday you are not here, Tuesday he is not here, and when we say next circuit, you say no, both of you. So what are we doing?
Since yesterday I have been taking attendance, I would be able to.
In the midst of two circuits, my brother says.
As an anticipatory bill, that is my apprehension.
Can be done, he has to be here with the material, otherwise how he has.
Well, I'll have to keep it on Tuesday, I'll try to. Who did here come?
Matters that. He's 39. All right. Okay. That's bad.
40.
The allegation is under 14A, 14C. The petitioners here are Indian nationals.
But we have not received this CD, I think it was filed yesterday.
No. 19. No, it will be submitted.
48 hours.
Indian.
So it is not 19, it is yesterday. Not today.
What? 41.
Yes.
41 I am for this year. CD is there now.
Yes, not.
42.
Answer the
42. 42.
I am the resolution, I don't know 40 years.
40 is over, sir.
So kindly just pick up.
Yes, you are.
42.
Can you make it?
Not today. Next.
Then I'm moving.
Next.
42.
Next.
43. 43. I am for the state.
I'm for the critical. I am 45 minutes from
43.
43. Service has been made minor of the victim. But I am representing by the mother of the victim.
That's right. Well, it is the 164. Good beginning, did not support the, ultimately, she did not support the prosecution case. In the
Minor.
164.
Minor.
Fine.
8.
39.
40. Now 40. Completely different story has been, but otherwise the case is good. You went to the house of the private tutor? He is the son of the private tutor. Accused is the son of the public, private tutor. He is
Son of the tutor.
Yes. She went to the house of the tutor. In his temporary absence, the son dies.
The fire part of your, well, page number 50.
Medical is 27. The medical states that the possibility of sexual intercourse cannot be ruled out.
BSP granted for the facto complaints submits that the Wakalatnama would be filed in the department during the course of the day.
এটা আমার
And another Raju, another region. Rachit, he has been released on 17/12/2024. Released. Till then, he was in custody. Before 17/12.
How you can get a bail in a commercial quantity within 11 months or 12 months, and why it should be confirmed? Let us hear. Why you should get a bail in 12 months in a commercial quantity unless there is material to lift the bar under section 37.
Then also granted.
No, that is an interim order that is subject to finalization. That's why we are asking you. How do you sustain?
Now, this petitioner.
There is no consideration in interim order on this aspect.
Lordship, actually,
you are aware that the three requirements are to be satisfied. One is a prima facie finding regarding no case being made out. Second is opportunity, and the third is likelihood of committing such offence. Where is the first satisfaction of the first condition?
Lordship, actually, the bar of 37, to my little understanding of law, there is judgments of the FS code even that delay in trial defeats.
3 years, we are aware.
Lordship, I have judgments even in 1 year.
Show us. That's why we are asking.
I am not expressing this case today, so I.
Show us. If you can show, then.
Lordship, is it in Monday then?
Already. That's great. Not the next case also you are appealing.
No, next case I am appealing, but it's not NDPS case.
Okay.
It was my council brief, so I moved that day. Lordship, 45. This is 302 method.
Interim granted earlier.
Yes, Lordship. Conditions page 5.
You are the assailant.
I am the assailant. It's about sole assailant. Page 5. Then out of 26.
My lord, I am for the de facto complainant.
The period of custody.
Lordship, I was in custody for more than 500 days and only 12 witnesses out of 26 charged witnesses were examined.
Lordship, in this matter, I am appearing on behalf of the de facto complainant.
After then only you can make your submission. Please wait for your turn. Yes, don't be impatient. Yes.
Lordship.
No, only I am appealing. Matter was sent for next circuit on 16th.
Yes.
Lordship. Analysis, para 3.
Yes.
The observation of the court.
That we have seen. What is the allegation against you?
Allegation
What is the manner?
Lord, the petitioner, my lord, immediately trespassed into the house of the victim, snatched away the ornaments, and thereafter he stabbed her.
Actually, Your Lordship, the case is some other way. That case is that after getting stabbed, the victim called her husband that I have been assaulted by someone, as per the case of the prosecution. And the husband comes, and there are several on the other day when I moved the matter, Lordship, there are several ambiguities in this case. charge sheet was filed and what happened was that Tribal Court and High Courts have that sector principle of the bail is not to be withheld as a punishment. Lordship, Javed Ghulam Nabi Sheikh's judgment was cited, though the order does not speak of same. But Lordship, the thing was that out of 25 witnesses, we only played that 12 witnesses have been examined, and there is no possibility of early disposal of the case. So
Occurrence
there
was
was
placed inside the house, then why are there 25?
prosecution.
Why there are so many witnesses? You just said that it was inside the house.
The neighbors, my lord, the police personnel, all have been, my lord, made witness. Tomorrow is the date fixed before the trial court for, my lord, the evidence. Thank you.
I am complying with your all court conditions.
But how do we know that you are complying with this?
Lordship, is there any, I don't know, adverse report to that effect?
No, my lord, there is no adverse.
No, like in the earlier case, you had placed on record.
Lordship, Lordship, gives me 5 minutes, I'll bring those because
So you place it on record.
Lordship,
Not today.
Lordship.
The learned counsel for the petitioner promotes that be placing on record the relevant material to show that the petitioner has been complying with the conditions of the interim bail. Stop the state council informs us that tomorrow is the date fixed in the matter in trial court. So we therefore direct that the case diary be returned to the police station so that the trial may proceed tomorrow without any hindrance. Let the supplementary affidavit be filed by the petitioner for consideration in the next circuit. We therefore extend the interim granted earlier. What is the date? What is the period of the next circuit?
Second of January.
Till
10th of January.
Till 11th of January.
Grateful.
Please return it today.
Actually, I have this soft copy, Lordship. I have to print out and grateful.
Grateful Lordship.
The number 46. 46. Thank you.
None appears.
47. 47.
I am for the appellants. I'm coming before your last court for the second time. But previously, my appeal was admitted on 24/9/2024. This case is started in the year 2016 and the appeals were arrested in the year 2017. 17. And they were in custody almost 7+ years. And they were in bail for almost a year. And during the
when were they taken in custody?
24/9/2024. That is after the judgment. For a year they were in bail. And during the enlargement liberty granted by the court, they received the liberty.
How long they have spent in jail?
7 years plus.
More than 7 years.
Yes.
Is the punishment.
3091. I'd like to cite this judgment considered by the output.
Judgment.
Now that all these submissions were made before a coordinate bench on the last occasion. And the coordinate bench, after hearing all the participants, please to turn down their prayer for suspension of sitting.
But this judgment is, order is given after the hearing of this our application.
So therefore, ignoring the order passed in your own case, an order of some other case should be considered.
Or in the same matter.
In your case, the order has been passed,
Thereafter,
which you have chosen not to assail before any higher forum. Then you cannot dispute or try to discredit that order. You have accepted it. Where is the order earlier passed?
Page number 9.
Page number 9. But on the same ground, this coordinate bench has considered after the day that my order was rejected, my prayer was rejected by the coordinate bench.
Your submission has no substance whatsoever.
Your
submission has no substance, Mr. There's an order passed in your case. How can you rely on another case? Just because just after that another order has been passed, the order becomes null and void. Your submission is devoid of any substance.
I have 4 daughters, 3 unmarried.
That we may say, but you can't say what you are trying to tell us.
And when I was in enlargement on bail, I didn't.
So this was at the time when he had been in custody for 6 years.
Well, it's September 2024.
Today he's saying 7 years, more than 7 years. Then he said 6 years.
They were arrested in the year 13.
Council, we asked you, you said more than 7 years.
7 years plus.
In September, it was 6 years. In December, it has become more than 7 years.
13, 1, 17, 18, 19.
Lack of solutions being made very surprising, very unfortunate. You have the brief in your hand, you have the order in your hand, and you are still giving us a wrong fact. Not expected from a advocate. Should be very sorry. It's a glaring so it is 6 years, not 7 years. Everything Kashmir Singh and all everything has been considered. And just after 3 months, you have renewed your it's to be done. Also for the appellant and the Leonard State Council.
I have prayed for an application for relaxation of condition of bail for one Devashish Pramani. And bail was granted on 9th of August 2024. And on the same date, another bail was granted to one Gautam Goswami in the same case connection. And thereafter, one CRAN application was filed on behalf of the Devashish Pramani, CRAN 1. And the order is at page 13, Lordship, where some of the conditions were modified because of his medical emergency. And he was allowed to enter into the Darjeeling and Jalpaiguri premises, for medical purposes only. And thereafter, one CRAN application was filed on behalf of the Gautam Goswami, and that his CRAN, in that CRAN application, the conditions were relaxed. Lordship. It is similar. That is also annexed here in the page 17, Lordship. I'm praying for the relaxation of the conditions of the bail of Devashish Pramanik, Lordship.
Where is the bail granted to you?
Lordship, page 11, Lordship.
But you said yours has already been relaxed.
Some of the conditions for medical emergency, it is at page 30, CRAN 1, and this is CRAN 2, Lordship. At page 30, last paragraph. In the same case connection, the conditions are relaxed. All the conditions are relaxed for Gautam Goswami. That order is at page.
Actually, Lordship, the petitioners are Gautam Goswami and the Devashish Pramani is different. They are different footing. One is direct involvement, another is subsequent event. That is different aspect. But they have earlier occasions, your coordinate considered that if medical emergency, they may be entered and the meet with the IO once in a week, your Lordships.
I have made all the conditions, Lordship, but charge sheet is not filed.
Yes, charge sheet is not filed.
What is the allegation?
Allegations here, Lordships, they are grabbing the property, landed property. And at 307 is also there in this case, your Lordships.
Against the complainant.
Again,
Alleged by the complainant.
Complainant.
So what is the difference in the role between him and the Gautam?
So far the investigations, the Devashi is the main persons.
How do you say that? That's what we are asking. How do you say? What is the difference in allegation?
Lordships,
Is there any difference?
different Lordships, the main persons have
If
mainly if grievance against the Devashis and subsequently after investigations.
That's what we are asking you to show. Where is that? Let us see. that there is a distinction in the FIR. What is the distinction? What does it say about him and what does it say about both of them? Is there any distinction?
Lordship, in this application, there is no distinctions.
In the FIR, there is no distinction.
In the APR, Lordship.
You are saying that one
Yes,
is main and one is a.
Yes, Your Lordship, but today is not a series available, Your Lordship.
Not available.
No. As because they have prayed for relaxations. Now, in the case of relaxation and modifications, it is not called for Your Lordship.
But at least FIR copy should be there. That,
If
you want to distinguish the case, you must have a copy.
Actually, Lordship, as and when the matter was taken up, I was there. When the matter.
Get a copy, we'll adjourn it not today. Get a copy. Only FIR copy is required, nothing else.
Lordship, they have the FIR copy.
Both are same.
Both are similar. They are the political influence and the.
And where do you reside?
Calcutta, under Calcutta place. But for medical emergency, I have to go to Siliguri and Jalpaiguri for medical purpose.
Who is stopping you?
Lordship, I am suffering from several diseases.
Who is stopping you from going to Siliguri and Jalpaiguri from medical treatment?
No one is.
Then why do you want further relaxation?
Lordship,
Just because it has been granted, you must be granted.
Actually, they paid for waive the condition to meet the IO. But my submission is until and unless charge sheet has been filed, they meet the IO once in a week.
Lordship, even
On that bit.
Yes, that condition they want to waive. That they will not meet the IO as because
Lordship,
my submission unless and until charge sheet has been filed.
But if he is suffering with the disease,
Lordship.
the kind of disease that he
Lordship,
is suffering with, how is it possible for him to go to the police?
Lordship, another.
Then Lordship, once in a fortnight. That can be. I just want to, they may keep contact clutch with the prosecutions unless and until file the charge sheet.
Lordship, one indulgence, Lordship. He is working, he's a government contractual government contractor and having several work orders, but he is unable to do that for as
He
he
is suffering with cirrhosis.
cirrhosis.
You have filed an application saying that he is suffering with cirrhosis. He
Yes,
needs
sir.
to get a medical treatment.
the
Now you are saying he is a contractor. You will say anything to get everything
No,
relaxed.
Lordship,
We
for
are
that
we
it's very-
are considering that medical condition that he is in such a situation, we may relax. You are saying he is carrying on government contract.
Lordship,
Then let him
as-
appear before the police station every day.
Lordship,
Why
Lordship,
should we relax?
Lordship, he is in
You
very,
record your
he
submission
is
that
in
he is
very
carrying.
vulnerable conditions.
What
Lordship.
vulnerable? Just now you said he is carrying on government contract.
He is unable to carry.
How can he? His medical condition does not
Yes,
permit.
that's Lordship.
Then?
One is his medical condition is very weak, and another one he has to
Cannot
stand
be both,
outside-
both cannot
outside.
be, both are mutually destructive. You cannot take both this plea. One that he is unable to do anything and the other that he is carrying on a government contract. You
He's-
cannot.
He is unable to carry.
Sorry,
The
you are
statement
not
can be
inclined.
there, Lordship, only the
Yes,
highly
yes,
considered
inclined.
medical condition, Lordship.
That is already there
Lordship, it's very hard to travel, Lordship.
and easy to carry on government contract.
No, Lordship, if
Very peculiar submission you are.
Lordship, it is very hard for him to decide outside the jurisdiction of Lordship, kindly consider.
That has
Lordship.
been considered. We are not inclined to
Lordship,
reconsider.
It's very
Any
hard to
further
travel, Lordship.
relaxation. Since the petitioner has already got a relaxation by the earlier bench under order dated 13/9/2024. However, considering the medical condition, we consider it appropriate that instead of every week, where does it say every week?
Once in a week.
Instead of once in a week, the petitioner would be required to intimate his whereabouts and if possible, meet the IU once in a fortnight. If not, if possible, if otherwise not prevented by medical condition.
That was the application, item 49.
Last occasion, my lord had asked for a fresh list of dates. We have prepared it. However, my lord, my learned senior is condition of health is not that great currently, suffering from high fever. Okay, so praying for not today, my lord. If the owner want have the short list of dates, I can also present it.
Where is your counterpart? He was just now here. So we had asked you to serve a copy before you gave us.
We would do that, man. Yes.
Have you given the copy?
Not yet, my lord. Just prepared it.
So what do you want? You want to give us now and give them a copy, or what do you want?
We can give a copy right now.
Then give us. The learned counsel for the petitioner has given us a list of dates after due service upon the counsel for the respondent. IOC.
IOC.
It is further submitted that the learned senior counsel is indisposed. So when do you want to?
As my lord pleases, Monday or next Saturday, whatever. Okay.
The matter is accordingly adjourned to the next.
Please.
But this matter, there's a defect in the equation.
How much time?
The line that I have calculated is.
Remove the defect. How much time you are
The only
requiring?
defect is the number of days. I have calculated 36.
Number of days.
Yes. Delay.
For
Delay.
in written.
Filing is madam, sir.
Oh, appeal.
Yes.
You filed an can application.
Yes, madam, can one. But I have calculated 36 days, department says it will be 28 days.
So the delay is on. What is the?
Madam, this is the state that is, there has been some time spent in getting the second up and therefore we can go to work. It's explained in paragraph 3 and 4 of my page number 4. Can walk.
Wrong with the order. What is wrong with the order?
No, the order included directed the operating concern, that is the tribal development department in making payment of the check. Well, the check itself was not issued by the implementing officer concerned. Takes a look at the implementing order.
No, that we have seen.
Yes, mother.
It's not a case that it was not issued by the competent authority.
But the direction has been made upon the principal secretary. So the principal secretary has not issued the check concern, and this check, mother, it is the specific.
The direction is to take necessary steps to ensure that the payment is done.
Yes, ma'am, but that check has already been, it has already lost its, it's not within the period of its validity. It was deposited, thereafter it was returned back to the petitioner, and the same was not deposited back to the bank within the time as prescribed within 3 months.
We presume you have read the order.
2018 check, mother.
We presume you have read the order.
Yes, mother.
Just see why it was not encashed.
Mother, it is stated there that the signature mismatch in the CBS database of the bank.
Correct. So the authority who was the authorized signatory in the bank.
Yes, ma'am.
It was not his signature.
It was not his, that was the question.
That was the issue. Then why for that the petitioner should suffer?
This check, the payment for the work done, this has been directly disbursed to the beneficiary is concerned. No work has been done by the petitioner concerned.
Where have you said that? Let us see.
In my memo. But takes up page number 4 of my.
No, you file a opposition.
But
In the rest proceeding.
no, but
Why?
no opportunity.
Why didn't you file an opposition?
No.
If you have chosen not to file an opposition, then what is wrong with the order? Again, we are asking. You cannot come up with a new cause of action or a new ground at every stage of the proceedings. This is inconvenient.
No opportunity was according to.
Where have you said that there was no opportunity granted?
This work concern, my lord, this work concern beneficiaries.
When you have chosen not to participate in the proceedings in spite of valid service, can you be permitted to say all this?
There was the state was represented, but though state was represented, no opportunity for filing the repeated was.
We don't see any such thing.
Considering
And we don't know why you were not represented.
the state was represented, state was represented in the Indian order.
Come to the second paragraph at page 2.
Yes, madam. And this is the development board, man.
So you have taken the work. You are respondent number 3. You are not represented.
But respondent number 3 is not the board. The respondent number 3 is not the board. Respondent number 3, this is the action is upon the principal secretary of the
Respondent number 3 is not the board.
No, madam.
Just see who is respondent number 3 in that order.
But this
please tell us who is respondent number 3.
This is the chairman of the board concerned.
Of the board.
Yes.
It is the board.
So we are representing this appeal is on behalf of the state. This has been filed by the state, not the board. Well, the board, the performer defendant here. Performer respondent here. How do you see the cost item? Oh, fine, remove it.
You have read them as a respondent.
This is appeal by the state. Because the principal secretary, that is state.
So it doesn't come within your department.
No, it has been payment. This check has been issued by the board without the necessary consent and authorization from the principal secretary of the department concerned. The government doesn't have any knowledge about this issuance of the check concerned, and the payment which is being referred to, Malad, that payment is already directly being made to the beneficiaries concerned in their bank account. The housing scheme beneficiaries have already received it in their bank.
From where do we get these facts we are asking?
Well, that I preferred in the memo of appeal.
How can you, for that you have to file a petition? Appeal petition, it cannot be.
I have already filed a stay application, can please. The state is contradicting the stand that is taken by the board by issuing the same check. Because this board independently issued the check without verifying it from the department's concern. No agreement was entered into between the between the department and the petitioner concerned, and no tender was issued for the work concerned. All of a sudden, the petitioner comes up and claims that he payment of a certain check issued by the board, allegedly from the board.
Serve the application.
But service upon the respondent numbers 1, 2, 3, regarding the service, the third respondent it has returned back with the comment that address this address could not be found. Return to sender, insufficient address, return to sender, third respondent, and the responding numbers 1 and 2 have been served, I believe, but this postal department has not updated the details of the.
File an affidavit of service.
Lodged, right.
Affidavit of service be filed.
Well, direction will be given to serve upon the landed advocate for the respondents, petitioners in the repetition.
How can that proceeding is now over? The moment that the petition is disposed of, the power goes.
And the insufficient address in respect of the respondent number.
You will have to find your defendant.
But it is the same address which is there in the repetition.
At least one of them, if they are appearing.
Yes.
We'll see.
1 and 2 they have to.
Therefore, we are saying at least file.
Lost.
The counsel for the applicant submits that the amounts which the amount sought to be enforced by way of the proceedings is the disputed amount. So the appeal has been preferred and an application filed seeking interim directions. So let the notice be served upon the respondents by speed post and affidavit of service filed in this regard by 4/1/2025. This in the next available survey.
Good.
One.
Next.
I'm very with the petitioner not to paying for next.
As paid.
I'm very fond of petitioner and praying for
As paid.
54.
order is order. Not today. We need to not today. We need order. We need to because the order is zero. It is the order. It is not today.
Fifty-five.
On behalf of the applicant, I break for next, sir.
Yes.
56 over.
56. 57.
56.
Yes, sir.
55. 56 in, my lord, I was directed to file affidavit in opposition. Kindly accept, I have to have the copy.
Affidavit in opposition taken on record as paid by learned counsel for the appellant. List in the next section. You have served copy.
Yes, copy has been served.
Each copy has been served on the council.
Okay, sir. 57. Fifty-eight.
Campaign for next. Yes, as paid.
59.
Campaign for next. As paid.
60. 61.
What should I bring for next?
Yes. Sixty-two.
Champagne for next. Champagne for next.
Sixty-three.
Bring for next.
64. 65.
Champagne for next.
66.
Subject 66, I will beg to appear for the petition. Chip, this is meant, like, affidavit can be taken on the last available date order will pass for serving the for copy of informal paper.
For a division bench.
Lordship, I confused the apologies, Lordship, I will possibly give it the next, kindly just.
Not today.
Lordship, if I may, kindly, I will give it to the.
All the next next.
Lordship. Yes, Lordship.
Sixty-seven. 68.
68 number. In a suit for declaration, partition, and injunction, petition, appellant before lordship is the plaintiff. My prayer for adequate injunction has been refused. Take out the. We are carrying out construction unless I am protected. There is no caveat.
Serve and come back.
By Monday. It won't be possible by Monday.
Obviously not.
Protection. I am the owner of the land. I have the record of right in my name. I have the title.
Both parties were hurt.
No. I didn't tell you.
I didn't show. Then let us see.
Now, one the owner was the original owner of RS plot number 33, which will also find a possibility of my injunction application.
Yes, please. They have not appeared there until now. Yes.
Well, if you kindly come to page 20, this is the record of right of the original owner. Thereafter,
On
his
the
son.
basis of LRO, you want
No, the deed has been executed in my favor, man.
the chain is not complete.
No, that to be decided as a.
Correct. So therefore, a prima
So
facie
that means
case.
I am the owner, I have.
Where is the
my
prima
name is
facie
recorded.
based on LRO, you will
My
claim the
name
prima
is
facie.
recorded in the RS, from the RS it is recorded. man.
On that basis, you will claim title.
Okay.
Let us see the law that you will claim title on the basis of RSOR and record of rights.
Dependent has also
Sir,
purchased a poster.
you have made a submission supported by law, we will grant you the interim order right.
Yes, dependent has also purchased from the RS recorded.
We are not concerned with the defendant's claim. We are here concerned with your claim. You say that on XYZ, it is sufficient that my prima facie title is established for a grant of an interim injunction. We are asking you to show the law. That based on LROR and some entry made in the revenue record, ex parte entry model should be passed in your favor.
But either record is not a proof of title. It is mere recording for collection of tax
So therefore,
and
now-
substantial possession. man.
Now, therefore, whether that
And the
is
substantial possession.
we don't. The court has recorded that your chain of deeds is also not complete. So we find no infirmity in the order passed by the court.
May I?
They once they
May I
appear.
rely a Supreme Court judgment?
Sure, that is what you want to see.
The paragraph 5, my lord. Paragraph 5.
First shows the fact, we'll come to the judgment later. Now move on. Where is the material that you have relied upon?
Yes, ma'am. On page 20.
Of the can.
Yes, can. This is the RS record of right of the original owner.
Again, you are saying RSOR, and that also is of the original owner.
Yes.
Where is your name?
Yes, my name is. Page 14. Page 40. My name is in the record of right. And the deed is at page 26. man.
You can't give us translated copies. Please be kind to the bench. Your rule requires filing of a translated copy. How can I appreciate what you are saying?
is the schedule of the plane. Schedule of the plane. And page number 40. Corresponds each other. Corroborate each other.
Page 14 it was forwards on the page 20 is the record of right of the original owner. Page 20 and there are page 25.
You are referring to page 40.
40 is my record of right.
Your record of right.
Yes. And page 20 is the record of right of the original owner.
So, in the schedule of the plane, you want to refer which plot?
Well, it's the same plot model where the defendant is also claiming some portion and I am claiming some. It is not partition now. It is an unpartitioned plot.
So from page number 40.
So the citation was there.
Tag number
288. LR plot now 288. And RS is
tag number is 188 in page 40.
188. I said corrected. And
one minute.
RS plot number is 33. RS plot number is 33.
So why are you referring to page number 40? Have you mentioned in the schedule of the plate corresponding tag numbers? LR tag numbers, this one. How can one relate?
I'm referring to 20 initially, which says the tag number is kindly also page 21, which includes plot number 33.
Yes, page 20.
20.
Whose name reflects? Repeats from that.
Pushpendra Dev Pona. And this is
Pushpendra Dev
Pona. And the next page, plot number 33.
In page number 20, what is the Khotiar number?
T700 1 by 1.
3700 by 1.
By 1.
That refers to your erstwhile owner.
Yes, ma'am.
From whom you were purchased.
No, from his son, thereafter inherited it. His name was written in the LR record of right, which you might be finding page 25. Page 25.
Yes, page 25.
Yes, ma'am.
It's LR record of right.
Yes.
You have not mentioned in the schedule of the plane. Learned counsel. From this viewpoint, you cannot.
People also kindly see the schedule of my purchased land the deed that I am referring to, page 45. Page 45. Clarification. There is copy of your application filed before the court. Yes, ma'am. Applications. Page 60, 60.
You also want to amend the plan.
Limited protection will be granted.
Unless
Just for the asking.
Defendant is carrying on.
Only for the asking. Without any semblance of title or any semblance of right, interim order should be granted. That also ad interim.
The seal deeds is clear on the partner.
We are not able to
Shows the
disagree.
Halda also the Shabik Dag also.
According to you, it may be. According to you, it may be. But we don't find any infirmity in the court's consideration. Based on the documents, of course, I am not in a position to tell. No, but I will rely on whatever is being, unless you give us translated.
No, I shall then come with the translator.
Not today.
Yes. A little bit next time, because by 2 days, so all the documents are in the.
Nine.
16 to 24 next Saturday.
70.
16 next Saturday.
70. 71.
There are two applications.
Yes, there is a two can. One is a conversion of delay for 167 days. And another is stay. Yeah, 167 days only.
Sir, on the
Rashid, kindly, 2 days in, 2 months in the direction to execute the deed.
Therefore you have filed after a delay of 168 days.
I have.
And then you are
Client
in
actually.
emergency. Serve a copy, what can be done? Serve the applications.
Rashid, the direction.
Yes. It's submitted by the also for the applicant. That copy of the application will be served on the respondents by speed post. An affidavit of service filed by 4/1. By 4/1 you will file the affidavit of service. This is the affidavit.
Twenty-two. 23. 74. 75.
My lord, I beg to appear on behalf of the appellant in item number 75, my lord.
Yes, please.
My lord, I'm praying for praying for time, my lord. Actually, my senior is traveling, my lord. So kindly fix this matter in the next circuit, my lord.
Yes.
76.
Much obliged.
Yes, as clear.
77. 78.
77, 78 একসাথে 70 এটি 79
80.
My lord, in 80, my lord, I appear on behalf of the respondent. I am appearing on virtual mode, my lord. My lord, there was a direction, my lord, upon the appellant to prepare and file the paper book within 8 weeks. And that order was passed on the 2nd August 24, my lord. The time expired. And pursuant to the order, my lord, I have put in the cost for special messenger cost for LCR. My lord, the appellant has not yet filed any paper book, my lord. And in fact, it is the appeal is from a money decree, my lord, on account of mean profit. My lord, they have secured the money. My lord, in fact, I had initiated execution proceeding pursuant to the order passed by the ordinate bench. My lord, they have secured the money. But I want early disposal of the appeal, my lord.
He is not here. Let us see. We'll just adjourn it, not today, or if you want, it can be taken up in the next circuit, because Monday, Tuesday, most probably it will not be taken.
My lord, as your lordship, my lord, I'll take a chance on Monday because either side is not here.
Senate counsel for the respondent is represented virtually. The appellant counsel is not appearing. Adjourns. Give the date of Tuesday.
Tuesday, lordship.
81.
18. Later is
Yes, he has appeared. He has
81.
We have heard him.
Lordship.
82.
But I make for next has played.
83.
The board is not functioning.
Yes. Actually, when the board very fast, then slow, not according to.
Then we call after 2 seconds. Don't do this, otherwise how will you want?
Yes.
You give a 2-3 second hold between the two numbers.
Is next two to three.
All right. So proceed accordingly.
84. 85. 86. 87. 88.
Lordship, I am for the respondent. 88. This matter was earlier dismissed for default and thereafter restored. Thereafter, appellant has not taken care of it. Considering these aspects,
Again, it should be dismissed for default.
not
Not
that,
today, no.
at least our attendance may kindly be
Yes,
recorded.
appellant counsel for the respondent is present. None appears on behalf of the appellant. Okay, let's go with the date of counsel.
89.
Grateful, Lordship.
90. 91. 92.
My lord, in 92, I am for the appellant, my lord. May I seek, my lord, the indulgence to fix in the next circuit bench, my lord?
Yes, as played next time.
Deeply obliged, my lord.
94.
Item number 90 to bring on next seven.
92 to.
All the list.
92.
Appearance to the.
94. 95.
36.
96.
Lordship, I am appearing for the petition and pray for next substitute.
As played.
Pray for the chief.
Appearance be
97. 98. 99. 100, 101,
Yes, sir.
102, 103, 104, 105, 106,
Lordship, 100, item number 102 and 3.
108, 109, 110 with 11, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 132, 133, 134, 135, 137, 139, 140, 142, 143, 144, 145.